Mr. Justice, Mr. Duncan, you both have incredible resumes. I enjoyed reading about both of you.
Thank you.
Only thing better than your resumes are your families. And I agree with everything Senator Feinstein said. I know you meant well, Mr. Duncan, but you got nothing to apologize to me about. I don't feel disrespected, and if I did, it wouldn't matter. I used to be the tax collector for the state of Louisiana, and this stuff is patty cake compared to that. It's been suggested that if I don't vote for you, that I'm not pro-life and I'm not pro-religious liberty, and I think we both know that's not the case. This is about picking. This is a one-time pick for maybe in my lifetime, maybe not yours, for a Louisiana judge to sit on the U.S. Court of Appeals for the Fifth Circuit. Now, let me ask you a couple. These are not trick questions, and if you could just give me a number or a yay or nay, there are a couple things I have to get out of the get out of the way. They may seem weird to you, but based on some of the past nominees that have come before you, I feel like I need to ask them. Mr. Justice, have you ever blogged anonymously or otherwise in support of the Ku Klux Klan?
No, I have not.
Mr. Duncan?
No, Senator.
Okay. Mr. Justice, have you ever described a child as being part of Satan's plan?
No, I have not.
No, Senator.
Okay. Mr. Justice, have you ever called a Supreme Court justice, living or dead, sitting or retired, a prostitute?
I have not, Senator.
No, Senator.
Okay. Mr. Justice, how many jury trials have you tried at the trial level as lead counsel to verdict?
I have not actually tried a case. I've been involved in a number of cases at the summary judgment stage, motion to dismiss stage, but I've never actually tried a case.
How many bench trials have you tried to verdict as lead counsel?
I have not tried a bench trial either.
Okay. Mr. Duncan, how many jury trials have you tried at the trial court to verdict as sitting first chair, or as we call it, lead counsel?
No jury trials, Senator.
How many bench trials?
I've done 2 bench trials, one in the Middle District of Louisiana and one in the Eastern District of Louisiana. Okay. Judge Feldman and Judge DeGravel.
Okay. Both good judges. All right, let me get this one out of the way because this 5 minutes goes real fast. Mr. Duncan, you heard my opening statement. Tell me what I say. I've gotten scores of calls from lawyers back in Louisiana who say, hey, you know, I'm experienced, I'm pro-life, I'm pro-religious liberty, some of them are judges. I'm thinking of a person, he hadn't called me back. What do I say to a person, for example, like Alan Seabaugh, as to why I would not pick somebody who's been in Louisiana for a while as opposed to picking somebody in Washington, D.C.?
Thank you, Senator. I would start with, I was born and raised in Louisiana. I was educated in Louisiana. I'm a double graduate of Louisiana State University, both the undergraduate and the law school. I clerked for a Louisiana-based judge. But more to the point, I have spent a significant and sort of prime part of my legal career and my reputation defending the laws of the people of Louisiana passed. And those weren't easy cases. It wasn't easy to go to the U.S. Supreme Court in the Thompson v. Connick case and defend that and try to overturn that judgment. It was not easy to defend Louisiana laws.
Let me stop you, Mr.
Difficult.
Because I'm about to run out of time. I got 30 seconds, and we've got a tough chairman. I want to ask you a hypothetical question, purely hypothetical. Let's suppose you were a United States senator, and you were sitting on the Judiciary Committee, and a very prominent attorney in this town suggested to you that if you didn't vote the way this particular attorney wanted you to vote, that you would be punished politically. I guess this is an ethical question. How would you handle something like that?
If I were a senator,
Yes, sir. Sitting on Judiciary. Hypothetically, of course.
you know what? I would say something that I heard you say in another one of these committee hearings. I'd say,
I didn't curse, did I?
No,
Okay.
no, not at all. I'd say come to Louisiana and run against me.
Okay. That's a pretty good answer. Thank you. I'm done, Mr. Chairman. Can we gentlemen agree that insofar as the judiciary is concerned, the appearance of impartiality is almost as important as impartiality?
Yes, Senator.
Yes, and our rules in Minnesota reflect that.
In other words, you can be the fairest person in the world, but if the people appearing before you don't think you're fair, they're going to lose confidence in our judicial system, which separates us from a lot of other countries. Can we agree on that?
That's absolutely
Yes,
correct.
Senator.
Okay. If you are confirmed, gentlemen, do you plan, while you're a sitting circuit court judge, to express your thoughts and observations to the world through social media, such as Facebook or Twitter?
Me first. No, I don't do social media, Senator.
Okay.
I do not express any professional views or views about the law. About a year ago, I sort of revived my personal Facebook page to share pictures of my kids and things like that. But
Excuse me
nothing
for interrupting,
professional.
but I mean, once you're on the United States Court of Appeals.
I probably will keep a personal Facebook page if that's allowed by the rules. I haven't looked into it, but if it's allowed by the rules, I might keep a Facebook page, but I would never express any professional views in that, any legal views or anything of that nature.
How about personal political views?
No. It's pictures and things that are going on with my family and friends.
I mean, you understand the problem.
Absolutely.
Yes.
Okay. This is not the bar exam, gentlemen, but Mr. Justice, a comment you made me think of a famous Minnesota Supreme Court case. Actually, it's a U.S. Supreme Court case. If you don't know about it, that's fine. But it came out of the Minnesota Supreme Court. Do any of you remember Michigan v. Long, by any chance?
The independent adequate state grounds case?
There it is.
Yes.
You remember that one?
Well, it's going to look like I'm cheating off of Justice Strauss, but I do remember. I'm
Very
on my
famous
oath,
case.
Senator. I
Very
remember that
famous
case.
Justice O'Connor wrote it.
Yes.
I want to ask you about penumbras in a legal context. Here's my understanding of a penumbra to the Bill of Rights. A penumbra is a right tangent to or implicated by another right that's explicit in the Bill of Rights. The U.S. Supreme Court in Griswold v. Connecticut found that the right to privacy was a penumbra, sort of indirect right, but still a very real right, implicated by other explicit rights in the Constitution. Bill of Rights to the Constitution, which actually, as you know, is the first 10 amendments. Are we on the same page here, gentlemen?
We're tracking.
Yes.
Okay. We know that there's a right to privacy, which it exists as a right, a penumbra right, let's call it. Do you believe there are others?
Who first?
You can go first.
Okay.
I think the Ninth Amendment recognizes that there are others. I think it says that explicitly. The reason Madison wanted that in the Bill of Rights was because he was concerned that if you list out certain ones, people will draw the implication that there are no others. And I think Madison wrote that in a letter. It's a rule of construction. It suggests that there are others. The question has always been, what are they, and are they judicially enforceable? And so the court has laid down certain tests to sort of cabin judicial creativity in this area. And as I understand it, the leading test is Washington versus Glucksberg, which, as you know, Senator, because I know you've talked about this with other nominees, this has to do with whether there's a fundamental right to assisted suicide in the Constitution. And the court lays down a test, and as I appreciate that test, the purpose of that test is to anchor the analysis in our public legal traditions as a nation. and not in the judge's preferences. That's a basic value, I think, that everybody agrees federal courts should share, and I think that's what's going on there. It's challenging to apply it. If I had a case come before me, now of course I'm not going to hypothesize about some case that come before me, but if a case come before me and that was the argument, I mean, I'd go back and read Glucksberg, I'd go back and read Cruzan, and figure out what was going on in that analysis.
I would follow Supreme Court precedent in this area, and to the extent that we're talking about unenumerated rights that we don't yet know, I think that's a tough question to answer, and maybe one I probably shouldn't answer, because the fact of the matter is somebody may file a brief someday that says, you know, we want you to find this unenumerated right in the Constitution, whether it be the Minnesota Constitution or the federal Constitution, and I need to be open-minded in being able to entertain that particular question. And so the answer is in the abstract. I'm just not sure.
No, sir. I'd like to ask one more, but I'll be quiet if you tell me to. I don't believe this will ever happen. But I'm curious how you would react. Let's suppose that at some point in the future, in a galaxy far, far away, the United States Supreme Court reversed its decision in Brown v. Board of Education and reinstituted the Plessy case. You're on the Court of Appeal. What do you do?
It's our duty as lower court judges, and this is true of the Minnesota Supreme Court. I would not like it. I would, but it's our duty to follow United States Supreme Court precedent. And if I was required to follow United States Supreme Court precedent with which I disagree, just like I follow Minnesota Supreme Court precedent with which I disagree, I'm going to do it because that's part of what I took an oath to do.
Senator, the Plessy is an embarrassing decision, and I think one major reason for me and probably for you too is that it's from our home state of Louisiana.
Yep.
And I remember reading that in law school and being embarrassed by it. If the court overruled Brown versus Board of Education, which, as you say, is not going to happen, then the first thing I do is pray that the people of no state would ever reinstitute a regime of legalized segregation in this country. Now, if they did, and a case came before me as a circuit judge, I'd apply the 14th Amendment. And I'd go and read scholars like Michael McConnell and others about the original meaning of the 14th Amendment. And I hope we'd get Brown back really quick.
In the meantime,
Thank you, gentlemen, both very much. Thank you, Mr. Chairman, for your indulgence.